Alex here with a legal nuts and bolts video on bias precautions or precautions of bias, I guess you could say. What I'm talking about is when a judge gives a disclaimer to the parties before presiding over the case. And the disclaimer is typically something along the lines of, I know this person, I met them in this capacity. I think I can be fair in this case. However, I'm just letting you guys know in case any of you wants to ask me to recuse myself or something along those lines. Basically, the judge is not recusing themselves. They are letting you know that you may want to seek their recusal or disqualification, and they're giving you the circumstances behind the relationship that they have with the party. However, it's really sort of them just putting you on notice to see what you have to say about it. My opinion is that most of the time when a judge is telling you this, they sincerely believe that they can preside over the case, but they want to comply with the rules of professional conduct and or the judicial canons, and avoid the appearance of impropriety. And so they are just kind of just going above and beyond to make sure that you know about the situation, and if you have a problem with it, to make that known now before they start to hear the case. And so I think most of the time the judge is doing this in good faith. I'm sure that there are rare circumstances where the judge has some ulterior motive. They want to definitely make a biased ruling against the litigant. However, they're complying with the canons and the rules of professional conduct, if that's what they are in your state. And so they're letting you know so that they can kind of cover their butt. It does trigger waiver if you do not try and disqualify or recuse that judge then and there when you have been notified, and you allow the case to proceed. You're not going to be able to come back later and claim bias. I don't know why some people think that's the case. It's like, well, the judge said they knew them and then they ruled against me, and so they're biased. Well, hold on a second. What if the judge said they knew them and then they ruled in your favor? Are they still biased? It's one of those things where people connect bias to the judge's rulings in the case, and the Supreme Court has stated multiple times that bias is connected to some kind of extrajudicial issue, something outside the case. And that's exactly what the judge is letting you know about before they continue and preside over the case. I probably, it's hard for me to say. I feel like I would observe the judge, and I feel 50-50 on it. I feel like I'm on the fence. I think on a case by case basis I would decide what to do. I think if the judge had a reputation for being incompetent or having other issues, I would ask the judge to recuse. But I think if the judge had a really good reputation, I would probably be like, okay, you can stay on. I really don't have any kind of hard and fast rule that I can give you guys on it. The reason I'm doing this video is because one of my friends mentioned, this is a good thing to bring up because it happened to one of his friends in a case, and his attorney recommended that he should just let the judge stay on. And the judge stayed on and then entered some rulings that he wasn't happy with. And then he was like, hold on a second, this is bias. So it's like, well, you had your chance and you let him rule. And there's all of these cases that would trigger to protect the judge and the decision and the other party, now that you've been told there was a connection with the litigant and you didn't say anything about it. Of course, the perspective for family court and family court litigants is that's not fair, because we feel like we have to say yes to everything because we're scared of the judge. And I get that people are scared of the family court judges, especially because they have so much discretion. If you want to learn more about why that's a problem, watch my video on the topic discretion. I understand that in those types of cases the judge has so much latitude that there's almost nothing you can do. And if you make a judge mad, or if the attorney makes a judge mad, then they're going to hold it against you later on and find all kinds of ways to screw with you. I get that, but the Supreme Court and the Court of Appeals, they don't really see things that way. They follow the same rules that they follow for all the other judges. They don't treat family court judges differently. So there is this perspective that in family court cases, you should just always disqualify the judge, don't take a risk. But that's not really my perspective fully. I feel like I myself, it would be based on that particular judge, their reputation, their actions. Not necessarily in my case, because I wouldn't have seen them rule yet, but just in other cases, I would probably do my research and determine what to do. You may be able to ask the judge if you could think about it. You may be able to say, you know what, can I get a continuance? Give me a few days to think about it. That might be an appropriate thing to do. If the judge says, no, you need to decide right now, that might be a good reason for you to say, okay, well, I want you disqualified. I haven't been able to think about it. I'm just going to err on the side of caution and ask you to get off the case. These are things things that I wish I had a better response to, but I do get emails about this issue. It does come up. It does happen. I mean, this is the best that I can do for you. I think it would be better if they would just decide on their own without asking the parties. If they really think that it's not going to look good, they should just recuse themselves and that's it. But there is some judges do it this way where they kind of just put it on the parties and ask the parties, what do you guys think? What do the attorneys think? And I feel like most of the time the attorneys are just like, oh, that's fine. No, you'll be fair. And the parties may, suffer the consequences there. The only exception to that might be if it's one of those cases that involves multiple millions of dollars and the attorney's a little bit more hard-nosed and he really doesn't care what the judge thinks, and he'll just boot the judge off the case just to make sure that his rights, as an attorney who's collecting a contingency fee, are preserved. There's a different sort of situation in those types of cases. Anyway, I think this is going to wrap it up for me. If you have any questions, feel free to post them down in the comments below, and I will see you guys next time.